Please have a seat, please. I'd like, perhaps if somebody could, if the folks outside want to come in, they should do so now. I'd like to have perhaps the doors closed during the speech because the student lounge is across the hall and it gets a little noisy sometimes, so we don't want that noise to intrude. So please, if you're still standing, there's still seats available. Please sit down. I assume everybody can hear me in the back, right? Correct? Okay. All right. Good afternoon. For those who do not know me, my name is Werner Steger. I am the Richard Raitano Endowed Chair in the Social Sciences and also the head of the Department of History, Government, and Economics here at DCC. It is my pleasure to welcome students, and lots of them. This is great. Welcome faculty and professional staff, as well as interested members of our local community to our annual Constitution Day lecture. I would like to thank Dr. Ellen Gambino. Is she here? Raise hand. Oh, she couldn't. Okay, she's at a meeting. That's right. There's a meeting today. But I would like to thank Dr. Ellen Gambino, Interim Dean of Academic Affairs, for her and the Office of Academic Affairs' continued support for these annual events. A note regarding the logistics here first. Professor Cole's lecture will be followed by a brief question-answer period. So when he's done lecturing, please do not jump up and run for the doors like you do it in my classroom, right? I'm just kidding, but it's like, don't do that, please, right? There's going to be interesting questions and answers afterwards. Unfortunately, however, we will have to end this event at 12:45 sharp, as Professor Cole has to catch a train to Princeton at 2:15. So I know that it's going to be an interesting talk, and people will want to hang out with him, and and it's unfortunately that's not possible today. So I apologize for that. Just because the word cell phone is in the title, that does not mean that they're going to be on. So please silence or turn off your devices now, okay? Please do not have your phones on. Now, Constitution Day became an official holiday in 2004 when, with the help of support from Senator Robert Byrd of West Virginia, the Constitution Day amendment to the Omnibus spending bill in the Senate passed. In May 2005, the United States Department of Education backed the law when it announced that it would apply to any school receiving public funding of any kind, which of course applies to us. When Senator Robert Byrd added the Constitution Day amendment in the Omnibus bill, he did so with the then recently passed Patriotic Act in mind, lamenting in his speech that if members of Congress had had a proper understanding of the Constitution, and I quote him here in his speech, we would not have to question aspects of the Patriot Act that might threaten privacy and due process rights of Americans, end of quote. Therefore, I think it's appropriate that today's lecture deals with the long shadow of 9/11 and its impact on our constitutional liberties, delivered by one of the most preeminent legal and constitutional scholars of the country. It is my pleasure to welcome and introduce Professor David Cole today. He is the Honorable George J. Mitchell Professor in Law and Public Policy at Georgetown University, the author of 7 books, most recently of Securing Liberty, Debating Issues of Terrorism and Democratic Values in the Post-9/11 United States, and the Torture Memos Rationalizing the Unthinkable, published in 2009 and 2011 respectively. He is also the legal affairs correspondent of The Nation magazine and has published his work in numerous essays in both scholarly legal journals as well as periodicals and newspapers such as the New York Review of Books, the New Republic, and the New Yorker. For those of you who are news junkies like me, Professor Cole is a regular commentator on NPR's All Things Considered. Apart from teaching and writing, Professor Cole has continued to litigate as a professor, including numerous significant civil liberty cases in the Supreme Court. So it is my pleasure to welcome Professor David Cole to Dutchess Community College. Please give him a hand.
Thank you, Professor Steger. And since Professor Steger said that this event has to end at 12:45, I'm going to give the shortest Constitution Day lecture ever, 5 minutes, 2 minutes for question, and then we'll be gone. I think it's 1:45 or 12:45 Central Time. Yeah. I want to thank you all for coming, and thank your professors who required you to come, and thank even more those of you who came without being mandated to do so. I would advise against texting or tweeting during this talk unless you want the National Security Agency to know that you are here and what you're thinking about. But actually, they probably already know that you're here and what you're thinking about, so go ahead and text or tweet as much as you want. So, we live in a brave new world, and you've probably heard old folks like me tell young people like you, often that we live in a brave new world. But in this case, I think it's true. In the old days, if the government wanted to find out your deepest, darkest secrets, who you hang out with, who your intimate associations are, what you're interested in, what you're reading, what you're watching, etc., it had really two options. First option was it could set an agent on you to tail you 24/7 and take notes on what you were doing at every moment of your day. But that is an extraordinarily time-consuming, expensive, and difficult to do. And so it rarely happened that the government would put the resources and time into doing that. The other thing they could do is that they could search your home. But in order to search your home, they would first have to go to a judge and demonstrate to that judge that they had good reason to search your home because they already had objective evidence that demonstrated probable cause that you had committed a crime or that you were hiding evidence of crime in your home. And absent such a showing, they could not search your home. And even if they searched your home, and even if they followed you 24/7, they would have difficulty determining what you were thinking inside your head, right? That's the old days. Today, if the government wants to know your deepest, darkest secrets, where you go at every moment of the day, who you're hanging out with, who you're communicating with, what you're reading, what you're buying, what you're interested in looking at. They don't need to send an agent out after you. They don't need to go to a judge and get a warrant based on probable cause and then come in and try to search your home and glean from things in your home what you might be thinking. All they need to do is go to the many private companies that you share at every moment of the day your deepest, darkest secrets with. By carrying your cell phone, you are sharing with the phone company where you are. Everybody who has a cell phone in here, the phone company knows that you're in here because that information is tracked by them on a constant basis, mostly so they can figure out where demand is highest and where to build the next cell phone tower and the like, but they keep those records. Your internet service provider knows who you're emailing, what your contact list is, what you're searching for on Google. Right? Google keeps track of that, as you know, because you search for something and then suddenly you start getting ads for it. Right? Anything that you purchase with a credit card, the credit card company has a record of that. So you put all those records together, and they will provide an intimate picture of who you are, what you're interested in, who you're interested in, and the like. And the government, under current Fourth Amendment doctrine, the government can get all of that information without going to a judge, without making a showing that you're engaged in any wrongdoing, because the Supreme Court, long ago in the analog era, before digital, ruled that when you share information with a third party, you necessarily assume the risk that that third party will turn around and give that information to the government. So if you tell your best friend that you just committed a crime, you assume the risk that your best friend might turn around and tell the government that you committed a crime. And therefore, you don't have, the court has said, you don't have an expectation of privacy in that information that you share with a third party. Well, they first ruled that in the context of friends, or I should say friends, informants, right, who come in wearing a wire, get someone to admit to some criminal activity, and then seek to prosecute the individual. But the government has extended and applied that third-party disclosure rule to all of the information that you share with a third party. Your banking records, your credit card records, your internet service provider records, your phone company records. And they take the position that since you've shared this with a third party, it's free rein for the government to get it without having to make any particularized showing of need. So privacy in the modern era, we've given up our privacy in the modern era simply by choosing to live in the modern era and not to live as a hermit off the grid. That would be the government's contention. My contention is that if we are to preserve the privacy that is so critical to both human development and a free and robust democracy, constitutional law needs to catch up to these developments in technology to assure that we don't sacrifice one of the foundational values of this country to the internet age. Now, this is a subject that I've been talking about in my criminal justice classes for a long time, and various scholars have written about it for quite a long time. But it's not a topic that really gained very much public attention until June of last summer, when Edward Snowden took it upon himself to download 4 hard drives worth of top secret information about what the National Security Agency was doing in our name to us, and then chose to disclose it to journalists who have disclosed it to the world. And that touched off what I think is the most significant debate, not only in the United States but globally, about the future of privacy and technology that we have ever seen in our lifetimes. And I believe that this debate and this question about how constitutional and human rights are going to protect us in the modern digital age is a set of questions that we will be struggling with, all of us in this room, for the rest of our lives. The developments will continue, and the challenges will continue. But I want to talk specifically about the challenges posed by the NSA program. So how should we feel about the fact that we have now learned that the National Security Agency, a highly secretive branch of the military, so secretive that people who worked there wouldn't even admit that they worked there, and people used to joke that that NSA actually stands for no such agency. Since Edward Snowden's disclosures of all the things they do, the joke now is that NSA stands for not secret anymore. But it is the National Security Agency, which was designed to collect signals intelligence not human intelligence, not spies, but signals intelligence, communications, electronic communications and the like, designed to collect those on the rest of the world, has, as we have learned from Edward Snowden, turned its attention inward to all of us. So what we have learned is that for the last 7 years, the NSA has collected phone data every time every one of us makes a phone call or sends a text. Now, they're not listening to the content of our phone calls or reading the content of our texts, but they are collecting data on who we call, how often we call, how long we talk, on literally every one of us every time we pick up the phone. And they're doing so without any basis for suspecting any one of us of engaging in terrorism, any other kind of national security threatening activity, or indeed even criminal activity. With no suspicion whatsoever, they are collecting all of our phone records, and then they store them for 5 years. They keep them for 5 years in a massive computer storage facility that they've built in Utah, and where they keep having short circuits because it's trying to collect and analyze so much information about all of us. And how should we feel about the fact that that program was adopted in secret, pursuant to a secret interpretation of a law that on its face no one would think would authorize the government to gather all of this information, and upheld by a secret court that heard arguments only from the government, not from the people, not from any of us, but only from the government that wanted to get the information, and authorized the government to do so, the biggest dragnet collection of personal data on Americans ever, without even writing an opinion explaining why it thought it was lawful for the agency to do so. And how should we feel about the fact that when Senator Wyden, who's on the Senate Intelligence Committee, asked the Director of National Intelligence, James Clapper, point blank in a Senate hearing where Mr. Clapper was testifying under oath, he said, Mr. Clapper, is the NSA collecting any kind of data on millions of Americans? And Mr. Clapper said no. He said no. He later said that was the least untruthful answer that he thought he could give. Now, that's a great excuse. That's the kind of excuse I'd expect my, 7-year-old to tell me. But, I can think of 2 more truthful answers he might have given. The first would be yes, because that's the truth. And the second would be what the government often answers when it doesn't want to disclose something in public. I can neither confirm nor deny, Senator Wyden. I'd be happy to discuss that in the closed session. You hear that and see that all the time. But no, instead, Mr. Clapper lied under oath to the Senate and to the American people, thereby concealing from the American people this program. It seems to me that there is something fundamentally wrong when our government adopts in secret a program that affects the privacy of every one of us without our say-so, without even notifying us that it's doing so, and lies to keep it a secret from us. A healthy democracy requires transparency from the government, right? So we need to know what our representatives are doing so that the government will in fact be democratic, so that the laws reflect our views. So if we don't like those laws, we can elect them out of office, we can make our views known, et cetera, et cetera, et cetera. And a healthy democracy also requires privacy for the citizenry. because without privacy, it's very hard to have the freedom to develop critical analyses of what the government is doing. So you need transparency from the government and privacy for the citizenry, yet what the NSA seems to have done is to turn that on its head, insisting that our lives be transparent to them and that their actions be secret from us. That's the very opposite of what a healthy democracy requires. So what I want to do this afternoon is simply describe the nature of what the NSA was doing, talk about why I think we ought to be concerned about what it was doing, and then close by noting some signs of hope. So I've already described in some measure this one of the NSA's program, the one in which they're collecting all of our phone data. And remember, it's phone data, it's not phone content. But it is on all of us. It is on all of us without any kind of suspicion. They also are collecting the content of communications, of email communications, of telephone communications, of chat rooms, and the like, from foreign individuals abroad. And there they're collecting literally millions and millions of communications. In fact, one of the documents disclosed by Edward Snowden showed that the NSA collects every phone call, the contents, it taps every phone call that occurs in a particular foreign country. They didn't disclose the foreign country, but in one foreign country they get literally every phone call. They record every phone call and then they analyze those calls. So these programs are about content, not about data, but they're targeted at foreign nationals outside the United States. But of course, in the modern era, it is increasingly common for U.S. citizens to communicate with people outside of the United States because people travel so much more than they used to, because communications are cheap, because the internet knows no borders, and so there's lots and lots of communications across borders. And yet, under this program, the NSA can collect this information, the contents of it, even if it involves U.S. citizens' conversations. Edward Snowden has also disclosed that the NSA was doing such things as inserting vulnerabilities into computer programs so that it could tap those programs and extract the communications information from those programs without telling anybody. And indeed, under another program, the NSA was intercepting computer orders from foreign places that were being filled out by American companies, and they intercepted the shipments, opened the boxes, inserted bugs into the computers, and then closed up the boxes and sent them along. Again, without informing either the customer or the seller that they were engaged in this activity. That they are collecting literally billions and billions of data on cell phone location use, that is, where people are with their cell phones around the world, contact lists and address books of people around the world, so that they can map the entire world. At least I think that's their goal. One of the slides, the NSA slides that was disclosed by Edward Snowden was called by the NSA, "Collect it all." Collect it all. That's their goal. So why should we be concerned about this? Well, I think there are a number of reasons. The first is the secrecy with which these programs were put in place. Secrecy, obviously there's a role, an appropriate role for secrecy in a democracy. You need to have confidentiality to do certain kinds of things, and intelligence agencies in particular need to be able to have a certain degree of confidentiality. But there's also a role for democracy in a democracy, and when you have secrecy not just about a specific covert action, but about a long-term, permanent, apparently, program that affects literally every American's private interests, surely at that point there ought to be some public disclosure of the fact that the government is doing this. And no one in the public knew that the government was doing this until Edward Snowden disclosed it. The law under which the government was doing this is a law called Section 215 of the Usa Patriot Act, and it authorizes the government in terrorism investigations to go to a court and get an order to go to a business and demand the business to turn over business records relevant to that specific terrorist investigation. And that was actually an expansion of the pre-existing authority, but it still required a showing that the records were relevant to a particular investigation. What the government did argued in secret to the court here was, well, we don't have to show that any of your phone records are relevant to any particular terrorist investigation, because at some point they might become relevant to a terrorist investigation. And as long as at some point in the future they might become relevant to a terrorist investigation, we should have the right to collect them all and amass them all now. And that was the theory that they advanced. A theory that when he learned about it, after Edward Snowden disclosed it, Jim Sensenbrenner, the Republican head of the House Judiciary Committee, who drafted Section 215 of the Patriot Act, said this was nowhere in his wildest dreams that he believed that he was authorizing such dragnet collection of information. And yet the government adopted that interpretation in secret, argued it in secret, and then got it sanctioned by a court in secret. That, I submit, is deeply disturbing in a country that is supposed to be a representative democracy. We also ought to be concerned, I think, because this kind of program intrudes greatly on our privacy. Privacy is important for a number of reasons. One, privacy is critical to the development of the human personality. We need a private sphere in order to have the kind of intimate relations that constitute who we are as human beings. That's why, most of us close the door to our bedroom when we live at home with our parents, right? We want that degree of privacy. That's why most of us close the door to our house or our apartment, because it's important to us to have a degree of privacy. To develop as human beings, it's important. It's also important to the democratic process, because what does the freedom to speak and the freedom to associate, critical to any kind of democracy, what does that mean if the government is looking over your shoulder at every point? So privacy is critical both to human development and to the political process. Privacy is not absolute, and it's never been absolute. The Fourth Amendment, which protects our privacy, doesn't protect it absolutely. It prohibits unreasonable searches and seizures. And the definition of what a reasonable search consists of has long been when the government develops probable cause that you're engaged in criminal activity, then it has the authority to intrude upon your privacy. Then the interests in law enforcement or security outweigh the interests in privacy, but not beforehand. Here the government is collecting all of this data without any showing that any of us is engaged in any wrongdoing. Now, some people say privacy is dead. Privacy is something that, old people care about, but young people don't care about it anymore. Facebook and Snapchat and all those kind of things, right? But I don't think that's true. I think people still close the doors to their houses and their bedrooms. People still password protect their computers and their phones. You know, sometimes they use not the best passwords like password, but they still, you know, are seeking to ensure that the information is not, their private information is not available to everybody. I think all of us recognizes the value of privacy, and particularly when our privacy has been intruded upon by a nosy parent, neighbor, friend, teacher, law enforcement officer, or what have you. The government also argues, well, this isn't such a big deal in terms of your privacy because it's just metadata. We're not listening, President Obama said, we're not listening to the content of your calls, we're just collecting the metadata on your calls. Again, that's who you call, when you call, how long you talk. But that metadata can be very revealing, right? It can show that you've called your girlfriend, your boyfriend, your ex-girlfriend, your ex-boyfriend, a drug rehabilitation center, a pregnancy counseling service, a rape hotline, a psychiatrist, a lawyer, a priest. It could show whether you've called a drug dealer or a fraternity. Maybe that's redundant, I don't know. But it can demonstrate a lot. And if you put all of your phone calls together, right, if we collect all your phone calls for the last 5 years, we can pretty much determine who are you associating with? Who are you regularly calling? Who are your closest friends? Who are your, you know, your less, you know, who are the people you never return their calls to, et cetera, et cetera, et cetera. Stuart Baker, who was the general counsel, the top lawyer at the NSA, said about metadata, he said, metadata tells you absolutely everything about somebody's life. If you have enough metadata, you don't really need content. And think about this metadata. The government's argument about why it can get your phone records would apply equally to your Google searches, your emails, your internet activity, your credit card purchases, right? Think about all that together. They don't need to listen to what you're saying to know what you're thinking. They can get it from the metadata. When I quoted Stuart Baker to General Michael Hayden, who was the former head of the NSA, in a debate a couple months ago that I had with him in Baltimore, he said, that's absolutely right. He said, we kill people based on metadata. That was supposed to somehow comfort us, but no. Then he said, "Well, we're not killing you based on the metadata. We're killing other people based on metadata." But the point is, metadata does in fact tell a tremendous amount about who we are and about our private lives. So saying it's just metadata is not an adequate response. The government also argues, well, you've shared the information with the phone company. So what's the big deal if we collect it for your security? Or you've shared the information with Google, so what's the big deal if we collect it for your security? Well, I think that there is a distinct set of concerns and risks that arise when the government has this information as compared to when Verizon or Google has this information for a number of reasons. One is that Verizon and Google don't have the power to investigate you, to prosecute you, to put you in prison. The government does. Verizon and Google don't have an incentive to target political dissidents. The government does. Verizon and Google don't have a history of using intelligence to harass people whose political views they don't like. Our government, unfortunately, does. Martin Luther King was spied upon by the FBI in the name of national security. More recently, it's been disclosed that the government has been collecting data on Muslim civil rights leaders in the United States. Not Muslim terrorists, Muslim civil rights leaders. It's also another document that Edward Snowden disclosed found that the government was collecting data on the various Arab radicals' visits to porn sites online, with the view towards delegitimizing those radicalizers by disclosing that they were visiting porn sites. Akin to what the FBI did with Martin Luther King, they bugged his hotel room, found him having an affair, sleeping with another woman, not his wife, and then threatened that if he didn't commit suicide, they would disclose this to the public. So Verizon and Google don't have that record of targeting dissidents the government does. And so it's one thing to say Verizon and Google can have this information because they need it for business purposes. It's another thing altogether to say the government should therefore be able to get it freely without any demonstration of a particularized need. So, are there any signs of hope? I think there are, fortunately, signs of hope. And one sign of hope to me is the very fact that when Edward Snowden disclosed these facts, it touched off the largest debate on technology and privacy that the world has ever seen. And it's a debate that's still going on, not only here but around the world. That's a good sign because it means that people are engaged, people are concerned, and it's only when people are engaged and people are concerned that reform might happen. We're already seeing some signs of reform. So as long as this program was secret, all three branches of the government seemed to be fine with it. President Bush put it in place. President Obama kept it in place. Congress passed Section 215 and reauthorized Section 215, even though some members of Congress were informed about this program as long as it was secret. And the courts, these special foreign intelligence surveillance courts, these secret courts that I've referred to, gave it their blessing as long as the program was secret. Now that it's been disclosed to the public, President Obama appointed an expert review panel which recommended 45 reforms of the program, and President Obama agreed unilaterally to accept a significant portion of those reforms. Another executive branch agency, the Privacy, Civil Liberties, and Oversight Board, investigated the program and concluded that it was illegal, that the program was illegal. Congress, which previously had continued to authorize the program, has considered about 30 to 40 bills to rein in the NSA, and the House has passed and the Senate is now considering the USA Freedom Act, which would put an end to bulk collection of this data and introduce a whole set of other reforms, including transparency reforms, to the NSA. And while the courts in secret in these one-sided hearings gave their blessings to the program, when it became public, there have been 2 cases filed in public challenging the constitutionality of the program, and one district court has said, in D.C., has said that it's unconstitutional. One district court in New York has said that it's constitutional. Both cases have been appealed to the appellate courts, and just last week there was an argument in the appellate court in New York in which all 3 judges appeared to believe that the program was illegal. So all 3 branches of government, once this became public, have shifted their position, and that's in part in response to the public outcry that has come from people who don't think that their records, their phone records, should be given to the government where there's no basis for believing that they've engaged in any wrongdoing. And more broadly, I think the courts have begun to recognize that the digital age requires some development in constitutional doctrine so that we preserve our privacy. So, for example, the 11th Circuit, a federal court of appeals in Florida, recently ruled that the government has to get a warrant to get your location data from your phone company. The government had argued, well, in the past, in the analog era, you, the court, ruled that if you share information with a third party like the phone company, we can get it from the phone company without having to have a warrant or make a showing of probable cause. And the 11th Circuit said, no, location data is different, because location data can tell a tremendous amount about a person's private life, and because people don't really, who asked you, do you want Google or Verizon or Sprint to know where you are at every moment of every day? We didn't voluntarily give that up. It's the nature of living in a modern society. The Supreme Court in the last couple of years has had 2 cases in which the government sought to apply analog era precedents to digital era surveillance, and in both cases the government lost, and lost unanimously. It's very rare that this court, a quite conservative court, rules unanimously for a criminal defendant and against the government, but in these 2 cases it did. The first one was called Jones versus the United States. It involved tracking of a car with a GPS device. The government was investigating this guy who they thought was a crack cocaine dealer. They stuck a GPS to the bottom of his car, and then they used it to track where he went 24/7 for about a month. And the government, there had been a case from the 70s in which the court said, well, you can follow a car from point A to point B without a warrant and without probable cause because it's in public. There's nothing private about traveling from point A to point B. And the government in this case said, well, if there's nothing private about traveling from point A to point B, and we can track that without having to get a warrant, then we ought to be able to track someone going from point A to point B to point C to point D to point E to point F 24/7 for a month. And the court said no, unanimously, and 5 justices said, because when you aggregate that data, even though each individual trip might be in public, we have a reasonable expectation of privacy that the government's not going to know where we go 24/7 for a month. And therefore, the government does have to get a warrant in order to put a GPS on a car. And more recently, just this past term, the court addressed the question of whether the government could search somebody's smartphone when you're arrested. And the analog era precedents, the old precedents, said when you get arrested, simply by virtue of the fact that you're arrested, the police have an automatic right to search you and any container on you, your purse, your backpack, your wallet, your pockets. They can search that automatically. And the government said, well, a smartphone is just another container. It's just like any other container. It's, as they said, materially indistinguishable from a physical container, and therefore the rule that we can search any container should apply to smartphones. Again, they lost 9-0. Chief Justice Roberts wrote the opinion, and he said, saying that a purse or a wallet is materially indistinguishable from a smartphone, given all the information that can be and is stored in a smartphone, is like saying that a horse and buggy ride is materially indistinguishable from a trip to the moon. They're both ways of getting from point A to point B, but that is the only way in which they are indistinguishable. And so the court said the police have to get a warrant before they can search a smartphone. So there is, I think, some sign that the President, Congress, and the courts are beginning to recognize that we need to adjust our laws to catch up to these advances in technology, and that unless we do, our privacy will be sacrificed. Now, I think those are signs of hope, but they are not guarantees of progress. And the only guarantee of progress is if we, the citizenry, insist upon it. The reason that these things have happened since Edward Snowden disclosed this stuff is because there was a great outcry when he disclosed it, because people raised their voices, because people and organizations committed to constitutional freedoms and privacy used these facts and advocated and for change. So I want to close with two quotes, and they both go to this the critical. I mean, they're actually very appropriate, I think, to Constitution Day, because Senator Byrd's idea in mandating some discussion of the Constitution, mandating discussion of the Constitution, was that unless we, the citizenry, are engaged in constitutional debate, unless we are fighting for our constitutional rights, they will be lost. Right? We had separation of powers. We had judicial review with respect to this NSA program, but as long as it was secret and the people didn't know about it, it just went right along smoothly. And it was only when the people found out about it, only when the people raised their voices, that we began to see some sort of change. So the first quote comes from Learned Hand. Learned Hand, many people say, was the greatest American judge not to serve on the Supreme Court. He certainly had the greatest name of any judge, Learned Hand. He was a judge on the Court of Appeals in New York, and he gave a speech called The Spirit of Liberty, in which he said, this was during World War II, "Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. No constitution, no law, no court can even do much to help it. While it lies there, it needs no constitution, no law, no court to save it." Now, like many great quotes, this quote, I think, both captures an essential truth, that is that liberty and constitutional freedom depends on us as much, if not more, than on the Constitution, that piece of paper, or the laws that Congress passes, or the actions of courts. Like many great quotes, it also oversimplifies the matter. I think the Constitution, laws, and courts serve to remind us of what our first principles are: freedom of speech, privacy, and the like. But I think he's absolutely right that unless we are vigilant about advocating and engaging in defending those liberties, we can't rely on the separation of powers, on the piece of paper, on the fact that Congress has the power to pass laws, on the fact that courts have the power to adjudicate disputes. We can't rely on those structures of government if we are not active ourselves. And so who protects liberty in this country? It's the groups that are organized around their commitment to constitutional rights. And there are many such groups. The American Civil Liberties Union, for one, and pick your right. For the Second Amendment, the National Rifle Association, right? It is protecting Second Amendment rights, whether you like them or not. The ACLU is protecting First Amendment and privacy rights. The Center on Democracy and Technology, a very effective advocacy organization that focuses on technology and privacy. The Electronic Freedom Frontier, another technology and privacy organization. The Center for Constitutional Rights, which is a New York-based nonprofit law organization that I worked for when I first came out of law school, the first group to challenge the detentions at Guantanamo, and the group that challenged the New York stop and frisk policy as racially discriminatory. These organizations are defined by their commitment to the Constitution, and you can get engaged with these groups. You can work with these groups. You can support these groups. You can create student chapters for these groups. You can join them as citizens, and you should, because they're the first line of defense with respect to our liberties. And finally, I'll close with a quote from Cornel West and Roberto Unger, professors at Princeton and Harvard, respectively, on what makes people get engaged in fighting for liberty. What makes people fight for justice? What makes people vigilant about liberty. And they wrote, "Hope is more the consequence of action than its cause. As the experience of the spectator, he who sits back, favors fatalism or cynicism, so the experience of the agent, he who gets involved, produces hope." And what they're saying there, I think, is that people don't get involved in fighting for our rights, in standing up for our first principles, because they're optimistic or because they're hopeful. It's the other way around. By engaging, by fighting, you produce hope. And so, to me, the future of our Constitution, the future of our privacy, the future of our liberties turns on, ultimately, on all of us, not being spectators who favor fatalism, but being agents who produce hope and change. Thank you very much. So I have time for questions, and they have microphones that they will pass out. So if you put your hand up, I'm happy to answer any question you might have, and they will come and find you.
Anybody has a question? Oh, yeah, okay.
No questions? Okay.
Very quick. Well,
No, it sounds like some.
hello, Berlin.
I gotta take it back. I guess we're going to the other side first.
Yeah.
Hi. So I think it's kind of related to the topic of like the NSA is net neutrality, which you might have heard of. It's basically companies that want to make the internet more like your cable, where you like pay for specific channels, you would pay for specific websites, and that's all you can access. And if you have more money or like you're more able to pay, you would have more access. So people want to fight that to keep the internet free as sort of a resource for everyone. I guess my question would be, how do you think that relates to our privacy, and like, do you think that that's an important thing to fight for, is keeping the internet free?
Absolutely. It's not directly related to our privacy, but I think it is related to our democracy and to our political freedoms and First Amendment freedoms in particular. Right? The net has become the street corner. Used to be that where was public discourse? Public discourse was in the park on, someone would put up a podium and you'd have people making speeches in the old days. Well, now, if you go downtown to the public park, you're not going to find any speakers, right? You're probably not going to find many people because they're all out at the mall shopping, right? So there's no longer this kind of public forum in a physical form in which we have these kinds of discussions. What's the public forum that has taken its place? It's the internet. And the concern that net neutrality responds to is that it is absolutely important that the net be free and open to everybody. That it be seen, that access to the internet be seen as a civil right, essentially, because it is critical to being an engaged citizen in our society. And if we sort of get rid of net neutrality and allow the biggest companies to exert monopoly control, then they will start charging us the kind of prices that the cable companies charge us, and and it won't be available to everybody in a free way. And there's concerns that there'll be high-speed access for people with lots of money and for sites with lots of money, and very slow access for sites without lots of money. And that, it's critical to me to maintain the democratic form of the internet, and that's why net neutrality is an important principle to fight for.
Characterize Snowden, hero or villain?
Thank you for that question. I think if I took a poll, my guess is that half the people would say hero and half the people would say villain. If you took a poll in Germany, I think 99% would say hero and maybe 1% would say villain. But here's my sense of it. He broke the law, and he violated his oath. When you work for the NSA, he was a contractor for the NSA, but even as a contractor for the NSA, you sign an oath saying, I will honor the classification system. I will not disclose top secrets to people who don't have the authority to see it. That's necessary. Those kind of agreements are necessary for an agency like that to operate. And he blatantly violated that by stealing 4 computer drives worth of top secret information and then disclosing them to the world. That is clearly a crime, and it's a very serious crime. On the other hand, he has, by virtue of that action, triggered, as I said, the most extensive debate on technology and privacy that we have seen in our lifetime. And he has triggered the reforms that I've talked about. And those reforms would not have happened, and that debate would not have happened, and we would not have known what the government was doing to us in our name without those disclosures. So he committed a crime. He committed a crime to further, I think in his view, a greater good. It would be up to a jury to decide whether they think that's the greater good or not. But I think, I certainly don't buy the arguments of some that he should be vilified because he's egomaniacal, etc. I think he's actually a very courageous person. Here he was, living a pretty good life, earning a lot of money. I mean, he never I think he didn't graduate high school. He was earning, something like $200,000 a year, working for the NSA, living in Hawaii with a beautiful girlfriend. He gave all of that up, his girlfriend, I guess it doesn't matter whether she's beautiful or not, but he gave up his girlfriend, he gave up his house, and it doesn't matter that the house is in Hawaii rather than in, Utica. But he gave up his house in Hawaii. It doesn't matter that he was earning $200,000 rather than $50,000, but he gave up all of that to live probably the rest of his life in hiding, in exile. And why did he do that? He didn't do that to make Edward Snowden a household name. It has become a household name, but he did it because he was concerned that the NSA was doing things to people that if people knew what they were doing, people would not accept it. And he was right about that. So the crime was that we didn't know what the government was doing in our name. He disclosed that crime, and I think that took a lot of courage.
There's one more. I think we can take one more.
Here's one right here.
I just wanted to ask a question about the contracts on games to go online and things like that. What did you think about that?
The contracts mean where you give away all your rights to get online?
Yeah, that.
Yeah. So one of the solutions to this privacy problems with respect to the internet is to say, okay, well, we'll give people the choice, right? We'll give people the choice. We'll tell them what rights they're giving up, and then they have to check the box saying they're willing to give up these rights in order to get access to whatever it is, a game or an app or what have you. It always says, read this thing and then check off this box saying you accept. How many people have read any of those things? Nobody, right? How many people check the box? Everybody, right? It's a facade. It's a charade. It doesn't actually serve any purpose except to give cover to private companies who want your private information, not because they want to spy on you, like the NSA does, but because they want to sell your information. Because, with targeted marketing and the like, that information, what you're interested in is valuable to advertisers so that they can target their ads to the people who are most likely to buy their stuff. That's basically what it is, but that's a multi-billion dollar business. And so we give up that information to private companies every day, and they use it every day, and that's the business model in the United States. It doesn't have to be that way. In Germany, and in fact across Europe, there are much more strict constraints on what private companies can do with the information you share with them. And they can't turn around and sell it to advertisers, et cetera, unless they come to you and get some specific additional consent, and they can't require that consent in order for you to get the service in the first place. But in order for that kind of regime to be in place, again, people would have to object, people would have to advocate, and laws would have to be passed. And until they are, we will live in the world in which we all check the box and give up all of our rights in order to play that game. Yeah.
As you said, democracy, for a healthy democracy to exist, we need privacy and secrecy. But privacy can also strain diplomatic and foreign relations. So would you argue that secrecy, in essence, is essential to our national security and it's required?
Yeah, yeah, I mean, as I said, I think I'm not for open doors in every situation. Even vis-a-vis the government. I think, when President Obama is consulting with his top team, that doesn't have to be in front of TV cameras with the world watching. To have a frank conversation, you need to have some confidentiality. All the more so when the United States is negotiating with a foreign country. There needs to be a certain amount of secrecy with respect to those negotiations in order for people to be able to try out ideas, et cetera. So secrecy and confidentiality serve good purposes, but they also serve bad purposes. They allow the government to hide embarrassing facts. They allow the government to avoid accountability, and they undermine our ability to assess what our government is doing. And so, it's hard to know precisely where to draw the line. But it seems to me, at a minimum, when the government is putting in place a massive program that affects the lives of every American, that kind of program should require some disclosure to the American people so that we can decide whether we think the trade-offs are worth it or not. I think now that we know, it seems to me that the consensus is that the trade-off is not worth it, and there are better and more targeted and tailored ways to identify terrorists than collecting data on every time I send a text to my daughter when I'm picking her up at school.
Okay. So how do you propose we can defeat or keep the NSA in check? Because I've heard some people in Germany, they've gotten really paranoid where they're thinking about going back to typewriters so they can't spy on them anymore. Also, who watches the Watchmen? How do we know they won't go out to check the NSA?
Yeah. Well, that is a great question. I think to me, transparency about the general scope of the laws that are being put in place and the general interpretations of those laws is absolutely essential. And if there's that kind of transparency, then I do think that the American public, the world public, the courts, Congress, can and will put some meaningful checks in place on what the NSA is doing. It's really the secrecy that sort of short circuits this process and allows the NSA to do things that it would not otherwise be permitted to do. So, to me, the most important reform there are two most important reforms going forward. One is transparency, and the second is going back to the model that the Fourth Amendment was based on, which is that presumptively we have privacy, and the government is permitted to invade that privacy when and only when it develops some basis for believing that we've engaged in some sort of wrongdoing. That's the model that we've used for 200 years. I think that's the model that we should continue to use and not engage in this kind of dragnet surveillance that the NSA has been using.
Okay, unfortunately, I think we have to end here. It's 1:40. But if you want to know more of what Professor Cole has to say, as I said, he's writing very, very regularly in popular magazines like the New Republic or the New Yorker, or so Google him. Google his articles, and you will.
But
Google him.
Don't surveil me.
So the NSA knows that you're googling, a critic. Okay. So I'd like to thank Professor Cole for his talk, and please give him another hand.
Thank you. Thank you.